Tribunal chairmen are conducting an inquiry into what's going on, but they're not all the same, are they?
No, it's interesting. I think tribunal chairs vary enormously around the country. So there's no one general description you can give of a tribunal chair. Some will intervene a considerable amount during the course of a hearing, particularly if they feel that one party is struggling or not understanding the issues or perhaps have lost their way in terms of the way the proceedings are being conducted. Others will say very little.
Do the differences between the tribunal chairs alter the way in which the case is conducted in your experience?
I think they do, because I think it's inevitable that if you're appearing in front of someone, you will go in and in the first 5 to 10 minutes, you will start summing them up in your own mind. You'll be thinking, is he going to ask lots of questions, or is she going to ask lots of questions? How should I put these points? The points won't change, but the way you put them may do.
If the tribunal decides that the claimant was unfairly dismissed, it'll reconvene to decide what remedy to award. This will usually take place straight after the decision has been given and is called a remedies hearing. Let's imagine that the tribunal's decision was that Julian Kirby was unfairly dismissed.
Ms. Pennell, I see from the claimant's ET1 that he claims compensation. Would you like to apply for reinstatement or re-engagement here?
No, sir. This is a claim for compensation only.
I understand that the figures in the schedule of loss are also agreed, and the schedule therefore provides us with the information that we would need to make the financial award.
So yes, the figures are agreed in principle, but what we don't agree, obviously, is the period of loss. That's the issue between us now.
The schedule of loss is a document prepared by the claimant setting out the value of his or her claim. This is Julian's. It's quite a short, simple document. It sets out the value of the basic award, which is based on his age, his length of service and his weekly wage. It also includes his claim for a compensatory award for financial losses suffered to the date of the tribunal hearing, for example, loss of earnings, and losses he's likely to continue suffering for a reasonable period after the hearing. When an individual has been dismissed, there's an obligation on him or her to mitigate their loss. This means that that person should try and find another job as opposed to counting on being awarded compensation at the tribunal. Claimants should make a detailed note of all the efforts made, such as the number of job applications completed, lists of jobs they've applied for, interviews attended, for example. This will be very useful when they're challenged about whether or not they've tried hard enough. And where a tribunal finds the claimant hasn't made any or enough effort to mitigate their loss, their compensation can be reduced.
Mr. Kirby, when you were dismissed from Hannigan's Brewery, did you try and get another job?
Yes, I applied for loads.
When did you start applying?
A couple of days after I lost my appeal. I couldn't afford not to.
And you kept a detailed note of all your efforts, didn't you?
Yeah, I did, yeah.
Could you turn to page 70 of the bundle, please? Is this a copy of one of your applications? It's to the Farmers Arms in Southend?
That's right. I didn't get it, though.
If you could flick through pages 70 to 138 of the bundle. These are all copies of job applications that you made, aren't they?
Yeah, it looks like them.
So were any of your applications successful?
The respondent's advocate gets an opportunity to cross-examine the claimant on the evidence presented at the remedies hearing. Claimants are usually tested in particular on their efforts to find jobs. For example, were enough jobs applied for? How long did each application take? It's for the respondent, though, to prove that the claimant hasn't done this, so they may find it useful in advance to research the number of appropriate job vacancies. If there were, say, 50 jobs, and the claimant says he applied for 10 jobs, then there may be good arguments to suggest the claimant hadn't tried hard enough. And this could reduce the amount of compensation the tribunal will award. Julian Kirby seems to have done a reasonable job of mitigating his loss, but this decision rests with the tribunal. The claimant is asking for 6 months' loss of earnings from the date of the tribunal hearing, but the tribunal may decide that he would find equivalent work within, say, 3 months and only award future loss of earnings for that period. The tribunal's decision will be influenced by the evidence that emerges during the remedies hearing. The tribunal will then undertake a calculation of what it considers the claimant is entitled to. What next for these parties? Well, the tribunal's decision isn't necessarily the end of the process, because either party can choose to appeal the tribunal's decision to the Employment Appeals Tribunal, if there are good grounds. There are strict time limits for doing this, and appeals can only be brought on the basis that the tribunal got the law wrong or came to a perverse decision. Unlike county or high court cases, a winning party can't ordinarily recover any costs from its opponent unless the opponent or its representative has acted vexatiously, abusively, disruptively, or otherwise unreasonably in bringing or conducting proceedings, or if in the bringing of the proceedings has, in the tribunal's opinion, been misconceived. If, for example, a party has pursued a really weak case or argument, then the other party may apply to the tribunal for their costs. There are different sorts of orders that can be made, and the level of cost is ultimately a matter for the tribunal or county court. The tribunal also has power to make a wasted costs order against a paid representative because of that representative's conduct. It can also make preparation time orders to compensate a party for time spent preparing their case when they've not been legally represented. The cost of pursuing a case to tribunal often influences the way in which parties choose to deal with the case. In some situations, respondents may choose to settle a case by paying the claimant compensation rather than paying its lawyers to fight the case. In other cases, there may be a good reason why a respondent chooses to fight the case all the way to a tribunal hearing. Either way, knowledge of the tribunal process should stand both parties in good stead. This has been a snapshot into the workings of a tribunal, and I hope it's given you a good idea of what really happens. Anyone can conduct a hearing. The key is to be prepared. We thought it might be useful for you to see a full closing speech in this case, so we're going to show you Hilary Winston's. Now, to deliver her closing speech, Hilary has to talk about some legal concepts which we've not touched on so far in this DVD. So before her closing speech, I'm going to try and explain those concepts to you. As well as deciding if the dismissal was fair, the tribunal often has to decide a range of related issues. On the facts of this case, both advocates will make a reference to Polkey, Section 98A of the Employment Rights Act 1996, and contributory fault. These are examples of arguments used by respondents to persuade a tribunal to reduce the compensation. The first argument is based on an old case, Polkey, where the respondent may argue that there is a high percentage chance that the claimant would have been fairly dismissed if it wasn't for the procedural mistake the respondents made. The tribunal can make a compensation deduction which reflects that percentage chance. A recent change in the law, Section 98A, means that if a respondent can show that it would, not may, have dismissed if there'd not been mistakes in the process, the tribunal can judge the dismissal to be fair. The tribunal can also listen to arguments that it was at least partly the claimant's fault he or she got dismissed. For example, if the claimant was very unhelpful or didn't turn up for meetings or disciplinary hearings, the tribunal may decide to reduce the claimant's compensation to make up for his or her behaviour.
Sir, we mustn't lose sight of the fact that this is the case of a theft from an employer, a case involving a very serious breach of trust. Here we have a respondent that had incontrovertible evidence via independent surveillance that a theft had taken place. Only 2 permanent employees, other than the glass collector, Gary Webb, work at the Come On Inn. As would be expected, therefore, both employees were suspended on full pay pending a disciplinary investigation. Upon being suspended, both employees received letters confirming the terms of their suspension, confirming the allegations, and asking them to prepare for a hearing. Both were given a right to be represented. Both individuals failed to deny at any stage during the proceedings that they had not done the acts of which they were accused. Both had opportunities to do that, firstly when they were suspended, and secondly at the disciplinary stage. The claimant went so far as to lodge an appeal, but still offered no explanation or denial. Now this is critical. In any situation where an individual is accused of something he didn't do, surely they would protest. It beggars belief that an innocent man would blithely accept an accusation of criminal offence and choose to say nothing. The claimant is also asking us to believe that he never once realised throughout a 3-stage process over a period of many weeks that he was the subject of a disciplinary process. He asks us to believe that he didn't consider that he had any case to answer. He wants us to accept that the respondent had no grounds to believe, on the balance of probabilities, that he was guilty of theft. He's asking the tribunal to rule not only that his total silence proved nothing against him, but that he should be financially compensated for the respondent's decision to dismiss him. The claimant's case simply doesn't stack up. It simply lacks the ring of truth. Now, as to the law, I've already provided the tribunals with copies of the cases that I intend to rely upon. Obviously, the burden of proof is on the employer to show that there was a fair reason for dismissal. Here, we say that the fair reason was conduct. Of course, the question is whether or not the employer acted reasonably within Section 98.4 of the Employment Rights Act 1996. In the case of BHS and Birchall, there are 3 questions to consider. Firstly, did the employer honestly believe that the employee was guilty of misconduct? Well, this hasn't even been challenged in this case. Secondly, did the employer have reasonable grounds for that belief? Well, we say yes. The evidence before it pointed to this. The combination of the tip-off, the surveillance report, and the claimant's silence was damning. I'm sure I needn't remind the tribunal that the employer's decision to dismiss must be considered in the context of what the employer knew at the time and not what has subsequently emerged. Now, the third question is whether at the time the employer formed its belief that the claimant was guilty, the employer had carried out such investigation and followed such procedure as was appropriate to the circumstances. The investigation must be within the range of reasonable investigations which a reasonable employer would conduct, and that's the case of Sainsbury's and Hitt. The respondent contends that it did carry out a reasonable investigation into the claimant's misconduct. The respondent put the allegation to him orally and in writing. It commissioned an independent surveillance. It held a disciplinary hearing at which the claimant was told he had the right to be accompanied. The claimant didn't deny the allegation. The respondent was at that stage, therefore, entitled to crystallise its viewpoint such that the obligation to investigate further was at an end. The decision to dismiss was the decision of a reasonable employer. If the tribunal were to find that the dismissal was unfair for procedural reasons, I would urge it to use the power provided by Section 98A of the Act to find that it was inevitable that if a fair procedure had been followed, the claimant would have been dismissed in any event. Of course he would have been. Finally, if I could briefly address the tribunal on Polkey and contributory fault. If the tribunal disagrees with my submission that the claimant would have been dismissed if a fair procedure had been followed, it must be the case that there was a very real and substantial chance that he would have been fairly dismissed and that he should lose a correspondingly substantial percentage of his compensation in consequence. Now, as for contributory fault, well, the claimant's total failure to respond to obvious questioning, and the tribunal must ask itself this question. He didn't respond at all, at any time. Is he really as stupid as he's trying to convince the tribunal that he is? I would urge the tribunal to consider that his silence during that period was at the very least a contribution to his dismissal, and therefore that his basic and his compensatory awards should be reduced accordingly, even if you don't decide to make a paltry reduction. Well, obviously, I would argue that it should be to the maximum of 100%. Thank you, sir. Those are my submissions, unless you have anything else that you would like me to address you on.
Thank you, Ms. Winston.